David Whiting, our talkback lawyer, is here to take your calls. David, good morning to you.
Good morning, John.
And congratulations. Last Friday evening, as part of Law Week, the Law Institute held their annual Law Institute Law Week ball, and David was provided with a certificate of...
I think it was a certificate of service.
Meritorious service.
They haven't told me what it was for, but I actually think it was for being in charge of a committee that we closed down on the basis that its functions were all being well performed elsewhere. So, you know.
No, it's for coming in and taking talkback calls every Tuesday morning at 10 o'clock.
No. But look, it was a pleasant night. Thank you very much. And sorry you missed the...
Oh, no, it doesn't matter. A bit of gossip.
Yes?
Apparently there's a bit of strife in the legal profession at the moment.
There's always strife. And we thrive on strife, John. Why?
No, this is a different sort of strife.
Okay.
There's all sorts of rumours swirling around the room. I haven't been able to pin this down yet, but I think someone's in a bit of trouble.
Okay. Right.
Trust account trouble.
Oh, right. Okay. Other people's money problem.
Apparently.
Oh.
Can't find out too much. It used to be you just had to ring the right person, they'd tell you, but now, oh no, people are so careful.
Well, we now know that, look at the Deputy Commissioner whose phone who was recorded on a telephone conversation.
Yep.
Yes. John, I have a couple of things. A former solicitor was sentenced to 9 months jail, 8 months suspended, and that means he goes in for a month. And his offence is practice when he wasn't authorised to practice. It was a second offence, and it was...
second offence of practising when not allowed to. So they rubbed out and they kept working.
Rubbed out and kept working, and then rubbed out and kept working again after having been given a suspended sentence the last time.
Rubbed out for dishonesty type things?
I have no idea what the original one. The answer would be it wouldn't. I don't think it is, because there was no suggestion of prior offences other than in the sense of failing to abide by a court order that he not involved himself in legal practice.
Right.
And he applied for a job in the country. He got the job. To all intents and purposes, everybody said what he did was fine and competent, but he wasn't the holder of a practice certificate, and he had an order from the court that he not engage in legal practice.
So a month in prison?
A month in prison, well, with 8 months suspended.
Yeah, but a month of go in there and just have a taste.
Yes.
And decide whether or not you're prepared to comply with court orders in future, or you can go in for longer.
Yeah, which is ouch.
I think that's a good way to deal with someone who's thumbing their nose at the regulatory authorities that way. I approve. Okay. Whoever made that decision, well done.
Well, you can read the decision on Ostley if you'd like, but there it is.
Is it VCAT still that makes those decisions?
No, the VCAT is involved in whether you can or can't practice. This was he'd been taken to court for, it was a contempt application. Okay. You breached the terms of an order that was made some 7 or 8 years ago.
And very seriously too.
Yeah, absolutely.
Excellent.
Now, John...
Apparently, the Legal Services Commissioner is due to retire sometime soon, and there's a search on at the moment, not just for a Chief Justice of the Supreme Court, Marilyn Warren, who finishes up in October. So they're just working out who's to be the next Chief Justice of Victoria, but they also need to work out who's to be the next Legal Ombudsman, the Legal Services Commissioner.
Well, it's interesting, John, because it's not the job it was.
No.
Now that we have national law and we have a Legal Services Council... that while it's the national law, it's just Victoria and New South Wales. And even then, the national law has been tweaked to suit Victoria and tweaked differently to suit New South Wales. Yeah,
so it's not quite national, but they're gradually inching towards something.
They are indeed, but it changes the role slightly. It's now doesn't have quite the original Legal Services Commissioner was also the chair of the
Legal Services Board.
Was the CEO of the Legal Services Board. So now
which looks after all the money from trust accounts and works out where it gets spent and invested.
Yes.
So yes,
it's an amazing system, John. They get an update every night of how much is in your trust account,
and making sure that in fact it hasn't gone AWOL. Quite importantly too. Anyway, so Michael McGarvey has been the Legal Services Commissioner, and as I reflected on Friday night when chatting to someone, he was an article clerk when I was an employee solicitor in the same firm a long time ago. That made me feel really old because he's retiring.
Well, he went on to be a partner, and then he became the CEO of the Supreme Court.
He did.
And then he did something else before this one. Anyway, the other thing that's interesting, there's a press release from the government today,
yes,
is that they've invested $800,000 to a an Australian pilot for an online dispute resolution service.
Pilot?
A pilot. So
not an airline pilot?
No.
No.
So it's a pilot program
right.
to investigate whether it would be possible to undertake an alternate dispute resolution system on a website.
Of course it is. It's being done. It's being done in Canada. There was the woman who came out here to the last conference where I emceed a session where she spoke about how they've already done that. The equivalent of VCAT in
Canada?
In whichever state it was. It might have been in British Columbia from memory. They've already done this. It's been up and running for years. She came out to explain how it all works.
I do remember a Canadian judge coming and talking to us about judge-led mediation and how to make it very effective.
No, this is all done. Everything is done just on a computer. So you submit your complaint and it's dealt with by the computer and someone oversights it, but by and large it's all automatic now. It's resolved. And then the really tricky ones go in front of a human being. The rest are just done by the computer. And
then on Friday night there was a presentation awarded to a firm which provides family law dispute resolution service. You know, in a sense, if the aim overseas as well as here is that how close can I get to telling you how a court is likely to deal with your application. This is what will happen. And then, therefore, it makes the negotiation significantly easier. And the same conference where the Canadian was telling about computer courts, robot courts, yes, there was a woman who does family law and her practice is entirely on Facebook. She doesn't have an office, whole thing's on a laptop, and it's all done through Facebook. It starts to scare me. Not that it's done through a website, but that Facebook owns your data, John. Much cheaper, keeps our overheads lower, provides a service to clients, saves them money, sorts out their problems, doesn't cost them anything like as much as going to see someone sitting in an office, paying for overheads, paying for staff, paying for rent, blah, blah, blah. Innovative. If it works in simple disputes, why not? Indeed. Anything else? Look, there was a fascinating case that in VCAT last week. If you buy a dog at a pet shop, and the suggestion was that the pet company, the vendor of the pet, did not provide or provided late or provided inadequately the buyer's name and address to the microchipping service. And the dog ran away. The buyer of the dog did not register the dog with council, and the buyer of the dog made a claim at VCAT under the consumer guarantees contained in the Australian consumer law. VDog or VCAT? Very good, very good. I should have called it a cat instead of a dog, but it was in fact a dog. And the tribunal found that the failure to ensure effectively that the microchipping advice was updated constituted a breach of the service guarantee. But isn't the similar breach that led to the loss of the dog, which can be, I understand, thousands of dollars, was the failure of the new buyer to immediately register it? Well, you were supposed to register it with council. Had it been registered with council, there wouldn't have been an issue. But in which case the VCAT also said you can have contributory negligence in VCAT. Okay, let's get to callers. Alan in Churchill. Morning to you, Alan. Good morning, John and David. Hi. My problem is that we inherited a caravan as a result of my wife's daughter's split up back in 2014. Yes. The arrangement was we'd keep it until a financial settlement was resolved, and that occurred over a year ago now. And so who got the caravan? I have no idea. Does that mean you're not talking to your wife's daughter? That's correct. Yes. And we're also not talking to her ex-husband, or he actually doesn't respond to communications. Yes. Right? So neither of them is prepared to remove the caravan. Yes. What's it worth? Not a lot. It was bought second-hand in 2010, and it needs repair, so maybe $1,000. Okay, there's a process. Have a look at the Australian Consumer Law and Fair Trading Act, and there's a series of provisions in there relating to the disposal of unclaimed goods. Right. And there are 3 levels, and the amount that you'll require, the effort you've got to go to, depend upon the value. Australian Consumer Law and Fair Trading Act. Back to calls with David Whiting, our talkback lawyer, and we'll bring you more information as it comes to hand at 22 minutes past 10. Kerry in Geelong. Good morning to you, Kerry.
Good morning. How are you?
Good, welcome. You're through to David.
Thank you. David, I live in the Golden Plains Shire, and our property is accessed via a dirt road, which on all maps show it is a dirt road, and it's called an unnamed road, but the other end of the road has a name. The problem is with the recent flooding that we've had around the area and all the council trucks coming up and down to collect garbage, the road is becoming very potholed, which is impacting my access to the property. And I've tried to get council to grade and maintain this road, and they've informed me quite definitely that they will not consider maintaining this road because it's not on their register of roads that they maintain, and there's no way that we could get it on that register.
Why could you not get it on the register? Are you the only person who uses it?
No, it's a public access road.
No, I'm not saying... I accept that you're telling me that it's a public road, but what kind of traffic levels does it have?
It has very low traffic levels. However, there's a winery next door, and to access their back paddocks to put fertiliser on, they use that road past our property. There is a property past us that can use that road. Fire trucks have used that road when there's been grass fires. It comes to the point where...
Kerry, can I say I accept all of that? I mean, yep. I don't... I am not sure what the criteria is, but the council will adjust its priorities having regard to the expected usage of the road. And I do not doubt that in any shire there will be roads that will be used on average 4 or 5 times a day. And I don't think you're going to get to the point where you'll say, well, I think it should have this level of service. I mean, it might be a discussion you raise with the Ombudsman about what's the criteria for getting on the list of roads that they look after. Yeah. That's where I would be. If you've got, I'm never going to put it on the list, seems to me to be the wrong answer from the council. But if the council was to say, based on its current level of recurrent usage, I think that it's adequate, and we're not going to maintain it. I don't know that you've got far to go other than the Ombudsman and say, wrong criteria. It's their road. It needs to be maintained to a particular standard. Please fix it.
Yeah.
So, Ombudsman.
Okay.
All right. Thank you, Kerry.
Thank you.
Good luck with that. Reg in Caulfield. Morning to you, Reg.
Hello, John. Hello, David. Look, sorry, this goes back a little while. I live behind a small group of shops in Caulfield, and the owner of one of the shops made application to the council to develop his site.
Yes.
Started off as 3 levels, and then council knocked that back, and so they went to VCAT, and then over the years it went to 4 levels, and then it went to 5 levels.
Yes.
It's like an arms race, isn't it?
Yes. As the years went by, it got bigger and bigger.
Yep.
At the last hearing, VCAT said, okay, you can have your 5 stories, but we're going to put a limit on it of 16.1 metres.
Yes.
So they issued whatever they issued, and it said...
A notice of intention to grant a permit, yes?
That's what it is. Yep. And they said this is binding unless it's revoked.
You can go to VCAT and say, these conditions are unreasonable on the permit, they should have allowed me to do X, yes?
Well, and they said that you can only, unless overturned by the Supreme Court or corrected, revoked or varied by VCAT.
Yes.
Mm-hmm. So, a couple of years later, the developer, the guy who owned it, sold it on to a big development company.
Yes.
The first thing they did was went to the local council and asked for a height extension.
By how much?
2 metres.
Yes.
Yep. So, time goes by and I'm thinking about this. So I wrote to VCAT and I asked them, if this was only varied by the Supreme Court or by VCAT, how could council change it?
The answer actually, Reg, is quite simple. The developer applies for a new permit.
A new permit?
Yes, because you can have multiple permits.
So it starts all over again, the process?
The process would then start again.
And you get a chance to object again, but
yes.
You've already ended up with what you previously ended up with. So they reckon there's a fair bet that they can make sure they don't go backwards, and they might even go forwards.
Reg, if you look at the planning in your area, you will see that over the last 2 10 years, the government has introduced higher density occupancies near major arterial roads.
Activity centres.
Well, no. Think of the activity centre as being an intensification of shops and commercial use.
Yep.
But if you're going to build a block of flats, the best place to build it is next to a train or tram line.
True.
So you're one street back or one house back from such a perfect location. So in terms of the intensification of development, you're just too close to the development to be intensified.
Well, sure, but how high is too high is your question, isn't it, Reg? And where does it stop? If they get 3, then they want 4. If they get 4, they want 5.
Happened.
If they get 5, they want 7, and on it goes.
I'm a bit concerned. I wrote to VCAT and I asked them how this is possible, and they answered me by saying, I'm sorry.
I can't give you legal advice.
We don't, and to hire a lawyer.
Yep.
Yes.
Oh, my God. I mean, that's obviously, to my point of view, silly. But anyway, you've answered my question. Thank you. They've just applied for a new permit.
Well, they may have. I mean, if you were concerned, you might go down to council and say, look, the order says it can't be changed. And if that's the case, then you've actually got to say to the developer, you don't have the ability to consider their application.
Okay.
But that doesn't mean they can't make a new one.
Reg, a text message suggests you've got an alternative.
Yes.
You should make a large political donation to the relevant planning authorities or whoever's in charge, and that way you then get what you want done rather than what your opponents want done.
Thank you. Last quick question. If it's still got the same permit number, does that mean that they haven't applied for a new permit?
Yep, then it's an application to vary the permit, yes.
Thank you very much.
Thank you very much, Reg.
Good luck. Ross and Geelong, you're through to David. Good morning, Ross.
Hi, David. Look, just calling my mum passed away just a couple of days ago.
I'm sorry, Ross.
Look, thank you.
Best wishes.
Thank you. It was peaceful. Yes. And look, she didn't have a lot to her name, maybe less than 20k super and a few thousand in the bank, but I just don't actually know what I do from here. She didn't have a will. And I wonder what my next step is.
And tell me, how many children?
2. So my sister and I, and we're teamed together. I most likely would be the one in charge of organising things.
So let's take this a step at a time. We've got a little bit of money in super and we've got some money in the bank.
Yes.
I take it the money that's in super is in a public fund?
I think it's AMP.
Yep, okay. That works. When you've got the death certificate,
yes,
which will show 2 children and 2 children only,
yep,
you write to the bank, to the deceased estate section at the bank, and you say to them, Mum's died, here's the death certificate, we're in this together, and what we'd like you to do is release the funds to us, and we're happy to give you an indemnity. We do not need to apply for a grant of probate because there are no assets for which a grant is required.
Great.
All right, now that deals with that one. You then write to AMP and you basically tell them the same thing. The super fund will make a discretionary payment or has the right to decide who's to receive the money as between her children, her partner if her partner's still alive, and her estate. But if her partner is no more,
so no partner,
then the answer would be you might produce your dad's death certificate, you produce your mum's death certificate, and you say it's clear.
Or a marriage separation, like divorce.
A divorce, that'd be perfect.
Yep.
Right. Just what we're trying to do is establish there is no one else.
No one else. Yep.
All right.
That makes sense.
And you write what's basically the same letter, and you and your sister would sign it, and you would send it after you get the death certificate.
Okay, now do you send the original death certificate or do you not risk that? You get what are called certified copies made?
Yes, so you get someone who can take a statutory declaration to certify a true copy, and you hang on to the original and you send off certified copies to the bank and to the trustee of the super fund.
As attachments to your letter saying, here's a copy, a certified, proven copy of the death certificate. There's no one else entitled. It's a small estate. It's not going to go to full probate. Here's where we want you to send the money.
Yep. Now, the trustee of the super fund doesn't require probate to pay you. They may ask you to provide additional information.
Yes.
The bank could ask you for probate, but the general proposition is if it's less than about $25,000, they just don't ask. They do ask you to sign an indemnity so that in the event that the payment is found to be wrong, you and your sister agree to repay.
All righty.
All right.
Absolutely. Thank you very much for your help.
Thank you, Ross.
Good luck with that, Ross. David, can we impose on you for a few more questions after the news headlines with Tim Callanan? Thank you, Tim. 26 minutes to 11. David Whiting, our talkback lawyer. We're going to grab a few more calls because we've had a bit of an interrupted session today, and then we'll get to the open line. And lots of text messages, David, about the situation that some of our callers have referred to. There was, I think, Reg from Caulfield. The developer will submit plans, put a curve in the facade, call it iconic, and get approval for a taller building. Someone speaking from bitter experience there. And Calvin says about the unsealed road, our caller from the country.
From Golden Plains.
Encourage one of the councillors to build a house and live along the unnamed road, and it'll be sealed in no time. That's what happened 30 years ago here.
She wasn't asking for sealing. She just wanted graded.
VCAT is useless for neighbourhoods. It's all for the property developers. They outgun any locals.
I think that's the problem, John. The issue is we try and have a system that works effectively and efficiently, but all the resources are on one side.
Yep. Let's get to VJ in Richmond, who's been patiently waiting. Sorry about that, VJ, but good morning to you.
Good morning, and thank you for taking my call, John and David. It's regarding a traffic offence. My wife was clocked at 29 kilometres over the variable speed limit. It had to come down to 70 on the Monash at about midnight.
Yes.
And it's very strange that we didn't notice it. I had a couple of drinks, so I wasn't driving. And normally when the speed limit goes down, it flashes. There didn't seem to be anything on the road to indicate a need for a reduced speed limit. So anyway, we are not planning to sort of dispute it. The question is, she's almost 70 now, and she's got a clean driving record for the last 18 years. And there are 4 penalties: conviction, 1 month suspension, 4 demerit points, and a fine.
Yes.
Is there three little questions? First, discretion for leniency.
The discretion will relate to the fine, not the points. So you've
right.
got.
No, actually, it's more in regard to the conviction and the suspension in that order. Is that mandatory conviction?
Can you listen next week, VJ, and I'll give you the breakdown as to what the consequences are. But certainly the points go. It is possible for the court not to impose a conviction, and you still lose the points. But in terms of your last question about the suspension of licence, I'll give you the answer next week.
Okay. The suspension is also not that important. It's the conviction, because I've been sort of told if you go to court and if the magistrate doesn't think you need that she should be treated leniently, that it could be a court conviction could be recorded, which would be different if it wasn't not gone to court and just the fine paid and the rap taken. The conviction would be recorded as a traffic offence and not as a court.
That's true. I do know that the general proposition, and I'll get you the answer for next week, is that if you pay a ticket, it doesn't constitute an admission of guilt. But again, I'll confirm that in relation to the traffic matters for next week.
Alrighty.
Thanks,
VJ.
VJ.
I ring back next week, or you just
you'll be listening at 10:05.
It'll be at the start when we do the catch-ups and homework and legal gossip. All right, VJ?
Thank you very much.
And last caller, Rick in Bendigo. Good morning to you.
Good morning, gentlemen. I've got a small query about water being discharged from a neighbouring properties. It doesn't comply to AS 3500.
Wastewater never does.
I've been to the council and asked the council to do something about it. The water must go to legal point of discharge.
Yes.
I'm a plumber, so I do know.
Yes.
And the council just got a deaf ear.
You have the right to bring your own proceedings at VCAT under the Water Act, objecting to the unlawful discharge of water from your neighbour across your property. Yes. So you can do it yourself. If you think the bit that gets me is about your concern about the quality of the discharge. Is the issue to the water flow or to the quality of the water that's flowing?
It doesn't really matter whether it's the quality of water or any water. The ground now, because of the water being discharged,
is oversaturated.
Is polluted.
Then the answer is you have the right to bring an action at VCAT under the Water Act. If you think that it's something that the council ought to be doing and isn't, and that their rejection is unreasonable, you can do what I suggested to Kerry, and that is you can raise the matter with the Ombudsman on the basis that there will have been some kind of approval given and that the water ought to be discharging appropriately. There could be a notice served under the Building Act.
All righty, Rick, I hope that helps you. David, thank you indeed.
Thank you, John.
Look forward to seeing you 2 weeks from now. Next week I'll be away, and Ben Knight will be in the chair looking after you next Tuesday while I'm away. And look forward to seeing you 2 weeks from now. 20 minutes to 11.